is Alex Fisher. I am the chairperson designee of the New York City Loft Board. I would like to welcome you to our April 21st, 2016 public meeting. We first turn,
I forgot to change that.
oh, it's May, I'm sorry.
Current meeting here.
But we do first turn to a vote on the minutes from the April 21st, 2016 public meeting. Are there comments, corrections to those? Yes, Mr. Delaney.
During the meeting, I had asked that the statement that I made, I'd asked that the statement that I made regarding the limited time that Loft Board members have to review cases in light of the circumstances where there are new topics or they're long cases or that they are cases that the staff have had many months to look at and examine. And I made a statement of several sentences that I asked to be put into the record, and I see that's been kind of whittled down to Mr. Delaney requested that the board members have more time to review the cases. Mr. Delaney believes it unfair to make board members review cases in less than a week. I did in fact suggest several alternatives that I repeated, and I am concerned that my request that that be in the minutes doesn't seem to have registered.
Mr. Delaney, the portion of the statement that you made asking to be put in the minutes, all of that was done during our discussion of cases. And at the time that you made that statement, it was gone into further statements about the cases. It is my understanding that even before I was the executive director, those discussions that were held after we began voting on cases was not contained in the minutes.
Well,
So we'll put it, you want to say it now before we go into that, so you can have it in next month's minutes?
actually I'd like it in these minutes when I made the statement. I can understand that the board has adopted a policy which one can argue makes sense, one can argue it doesn't make sense, that there is no discussion about the specifics of a case recorded in the minutes. In this instance, my comments were not specific to the facts of that case and were in fact a topic that I've discussed several times, in which I first broached in a letter to you and the chairperson designee back in, I believe, February of 2015. So, how would you like to proceed?
Mr. Delaney, I looked specifically at the YouTube video to see in what context your statement was made. And because it was also regarding some of the aspects of our discussion on cases, I could not put it in. We did put in just something that spoke to what your concern was, but I could not put in. I would have quoted you word for word, but for the fact that it was done during the discussion of the cases, and in your conversation, in your statement, you were also referring to things that were relevant to the cases that we were discussing.
How would you like to proceed?
And the statements are on the video.
I appreciate that we're becoming reliant on the video, but in this case, how about I suggest this? Why don't I write out a short statement that scrupulously avoids any specifics of any case and provide it to you with the request that it be added to the April minutes.
But that doesn't actually reflect the meeting. So perhaps what you might want to do is do that for this meeting, and it would be reflected in whatever you want to say now. We're not discussing cases. If you want to say it now, you can go in this month's meetings.
Sure, that's fine.
Okay?
Sure. Would you like me to state it?
Please.
Okay. And I do want to take just one moment to note that the board's practice of not containing discussion of facts of cases is the current method by which the board chooses to proceed. There's nothing in our rules that precludes that. And in the past, different approaches have been taken. So I find your conclusion there, your conclusion, not something that is necessarily contained in the rule book. So, for the record, with no cases in front of us, it has been the board's practice over the past decade or more to provide members of the board with the cases at about 5 p.m. on Friday, the week prior to the board meeting, which gives board members less than a full week to review cases. For a number of years, when the cases coming before the board were, for the most part, following cases that had been, precedent that had been set in prior cases, that was an accommodation that I was able to make. Now I find, particularly when we're headed into areas that are new to us, in addition to the whole protected occupant question, we've been advised that we will start getting window cases and incompatible use cases. The amount of time necessary for me to be able to prepare and feel that I've discharged my responsibilities is very difficult to accomplish within that time frame. I suggested that board members be given 2 weeks, or in the alternative, that if a case comes out that a board member feels that he or she cannot fully prepare for in the span of time of 6 days, well, 1 weekend and a work week, that the board member be allowed to request that that case be laid over. Those are the 2 suggestions that I made back in February of 2015. And the last point that I would like to note is there are many cases, such as one on today's docket, which I will not mention by name, where the board has been in receipt of a report and recommendation from oath for 10 or 11 months, and to have the board staff have the opportunity to weigh, consider, research, look at other opinions, study the arguments of the parties over a matter of months, and then have the board members have less than a week to review the case, to me seems to be a real matter of concern.
I would just like to respond to one thing that you have said, just to make it clear. Even though a case has been back from oath for 11 months, does not mean that we have been looking at it, mulling over it, writing it, preparing it, discussing it, or anything else. It means that it's waited its turn in line. And the month that it comes up as going to the board, it has exactly 1 month that we deal with it. And what we do is we prepare it for you. That's our job. So that hopefully you would, all of you, have presented to you in a concise and readable manner the analysis of the legal staff as well as the backup, so that you can more quickly than me reach your conclusions and any concerns that you have. But to say that we have 11 months to consider a case is just wrong. That's all I have to say.
That's going to be it on this subject. You can all look at the video for everybody's comments from the last time, and I appreciate that. So turning to our April 21st, 2016 minutes, are there comments or corrections to these minutes? And I understand that this, what you were just speaking of, will go into this month's minutes. So
That's my understanding too.
that's right, fair enough. Anyone have comments or corrections to last month's meeting minutes? No. Okay. Is there a motion to accept those minutes? Mr. Gregory, thank you. Is there a second? Thank you, Mr. Carver. You pull the members, please.
Mr. Carver.
Yes.
Mr. Barber.
Yes.
Mr. Gregory.
Yes.
Chairperson Fisher.
Yes.
Mr. Deline.
Abstain.
Ms. Bolden Rivera,
Yes.
Mr. Shacklet.
Yes.
6 in favor, 1 abstain, and 1 absent.
Thank you. Lanny Alexander, our Executive Director, will now give her report.
Good afternoon, everybody. I left my notes back at the office. Didn't get printed out with everything else. I apologize. So what I wanted to speak with you all about today was the Article 78. I sent you the Article 78, the determination in the Plymouth Street case. I also, because it was difficult to read, wrote to you in the content of the judge's opinion. I wanted to tell you, as I did in the email, that the law department has filed a notice of appeal. And we had 3 cases like this. One we called Parish, which we won in an Article 78, where the judge completely understood the policy concerns of the law court. This recent decision, which actually doesn't say anything except that we were arbitrary and capricious, but gives no actual rationale for it. And we have one more that is pending, and that is South 11th Street. And that has recently had a settlement conference at which we were invited to attend. The judge quickly realized that based on our position, there was not going to be a settlement, but Martha and I spent about an hour and 15 minutes telling the judge about the loft law and the loft board, and educating him as to what our practices were, what our policy concerns were. It was really, a very fruitful discussion. I'm not sure how he's going to come out of this, but you will all hear that. Oral argument has been set for the beginning of July in that case. The building in question has 6 tenants that applied for coverage and subsequently settled. We came to realize that there are 30 units in the building. They believe that they're going to have their certificate of occupancy in 6 months. I don't think any of us really hold much hope that that's going to happen. So it really is going to be a matter of what happens first, the judge's opinion or mooting out the case by getting a certificate of occupancy. But I just wanted to tell you that whatever happens, we will still be going to court with regard to the Plymouth Street case. And that was all the interesting things that I had to tell you this month.
Could you just, there were 6 applicants in South 11th, but there are 70 units?
No, there are 30 units.
30.
I said 70.
No, I think you may have said 30.
There are 30 units. So it becomes even more problematic. And also, I would say that having 30 units rather than 6 makes it a little bit more difficult for them to get a certificate of occupancy so quickly.
No further questions.
Okay. So now I turn it back to you.
Thank you. We turn next to the summary calendar. There are 7 summary cases. These cases are voted on as a group. They are 60 Beach Street LLC, 48-60 Beach Street, LB0191, Jacques and Sylvie Sell, 365-369 7th Avenue, TH0203, Charles J. Esposito, 48-60 Beach Street, TH0206, Jacques and Sylvie Sal, 365-369 7th Avenue, TM0082, Jacques and Sylvie Sal, 365-369 7th Avenue, TN0224, Northside Lofts LLC, 239 Banker Street, Brooklyn, TR1218, Courtney Butler, and several other names, 239 Banker Street, Brooklyn, TR1258. Questions or comments about these cases?
I just have one question. Do we know, I didn't have time to research this, whether or not the named applicants in case number 7, Courtney Butler and the rest of them, their units were registered, but were those individuals identified as protected occupants?
The answer to that question is no. Some of the tenants were registered as protected occupants on the owner's registration application, but not all of them. The units were all registered.
But the owner registered some of the applicants, but not all.
Right.
So even though the applicants applied, based on the foregoing that he registered the units, we're dismissing the application as moot.
The applicants applied for coverage of the unit, not for protected occupant status. And the registration, the owner's registration will rule out the tenant's claim for coverage of their units.
Okay, embedded in that would seem to be the statement that going forward it's incumbent on anyone making an application for coverage to say, I'm applying both for coverage of the unit and for coverage as a protected occupant.
Yes.
And this is a piece of the evolving case law on this matter. There's nothing in our rule, we have no rule that speaks to this, am I correct?
No.
No?
That comes out of the legislature's time to limit the applications for coverage. So you can file an application for protected occupant status after that time limitation, not for coverage. So after June 2017, you can still apply for protected occupant status, which is a different claim, like a different section of our rules, but you can't apply for coverage of a unit or a building.
You know, it's hard to take notes and fathom at the same time. Could you just repeat that for me one more time?
Sure. The legislature has set a timeline, a time by when all applications for coverage of units and buildings must be filed. Before, when it was in 2014, the board took the position that after that deadline, the tenants can still apply for protected occupants of spaces that were covered, or at least had an application for coverage pending. They separated the coverage for a unit and coverage, or really protected occupant status.
This is a very interesting interpretation, which I don't think I've really heard before. They separated. They, the legislature?
Right, the legislature put a time frame on when applicants for coverage for units and buildings must be filed.
In 282A,
Yes,
in 2010.
yes.
Right. And we then said that we would, after March 11th, 2014, continue to accept applications for protected occupancy status in units that had been found to be registered. That were covered.
Yes.
Okay. So what did the legislature do? I understand what we did.
Put in,
What I believe that you do understand, Mr. Blaney, is that by the fact that the legislature did not create a statute of limitations for both coverage and protected occupant status, of course, it wouldn't have made any sense, because people can apply for protected occupants, can become protected occupants who weren't window period tenant, didn't live there before the effective date of the law. There are means that people can be protected occupants in 2017 and 2018. because the legislature only barred the coverage application, but was silent with regard to the protected occupant status application, that somehow in the past had all been sort of glommed together. Perhaps, I don't know. To me, they were always two distinct things, two distinct claims. The proofs were always, were often gone over apart from the coverage application. They are two distinct causes of action. So if you are only claiming coverage of your unit, it would be, as you say, incumbent upon you to also add that you want to be found to be protected occupant, and also present your proofs for that. And it is not really about our new improved determinations of protected occupant. It really has nothing to do with that. It has to do with notice, due process. It has to do with what the legislature did in barring one thing and not the other. And so, yes, now we are looking at these things, and really what I would like to say is that Ms. Cruz, in particular, and I to some extent, have tried very hard to do these things and interpret the law and the rules the way they're written, and to stick by them. And in that, we look and we say, you applied for coverage, we will determine coverage. If you applied for both, we will make both determinations.
Is there any rule for an application for protected occupant status?
To make the determination? Is that what you're
Is there any rule that one person's new and improved view, I am not convinced that it's not ultra vires, and I hope that gets tested in a court of law as soon as possible. If what you're saying is going forward, I need to file an application that says I'm applying for coverage for the 3rd floor at 76 Pearl Street as a covered unit, and I'm applying as Chuck Delaney to be the protected occupant, and I need to be prepared to offer proofs not only of residential use, but to establish that I am the protected occupant. It seems to me that that ought to be very clearly stated in a rule, which I don't believe it is, and I think it's a sucker punch. And as we evolve, as the Section 280 of the Loft Law states that, or Section 282 rather, states that the Loft Board was created to resolve disputes. And I think in this case, we're actually creating disputes with the current interpretation of protected occupant status. I know that for 30 years, nobody filed for coverage necessarily using that language. If that's what they need to do going forward, and if the no, I'm kind of looking at the wrong case. If the 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 people on TR 1258 needed to make that filing, and therefore the units are now covered, but they're not the protected occupants, it seems to me that there's a responsibility for the board to be clear about this in a way that it's not been clear.
Can I just interject right here that one of the issues that I see in what you're saying is that if somebody files for coverage and there is nothing in the record in any way, shape, or form that would support a finding of protected occupant status, how can we possibly so find? If, for example, somebody files for coverage, they have a full hearing. During the hearing, they make the claim, and they didn't put it in their coverage application, but they make the claim, it is accepted, it is argued, it is proved, they provide proofs. then that's what we look at. But in a situation where somebody applies for coverage and then there's nothing, how are we supposed to find protected occupant status? Under what part of 209 would we so find?
In my opinion, 209 was never created. It was not written as what was then a regulation to address coverage. It was articles of subletting, subdivision, and assignment.
No, it wasn't. It was coverage.
Protected occupant.
It was protected occupant status. It said so in the overall caption. And in all of it, I mean, how would you say that subsection 1, 2, and 3, even if you don't like the interpretation of using subsection 4, is not what we use to determine the protected occupant? If you come in and you have a lease and you weren't there on the effective date of the law, you can be a protected occupant, but you have to show us that you had a lease or were in some way privy with the landlord. So you don't just, this is where we look. And if you don't give us any of that, then, you know, you'll have to apply, make a separate application for protected occupant status, provide your proofs, and then if it's true and you made your proof, you'll be the protected occupant. But if there's nothing, how can we find protected occupant? This pulling your hair.
I guess I'm a little unclear. I understand what you're saying, but did we change the procedure in the way we were looking at these cases?
The only procedural change that we made was the one that we made after the statute of limitations expired. And in that case, what we did was we created the protected occupant docket abbreviation. Always, the protected occupant status and the coverage application were all subsumed into one. But if you applied for coverage and you did not provide any proof or any claim during the time period that your case was pending, there's no way we can find protected occupant status.
I understand that part. I guess the only thing I'm wondering is if in fact we changed the way we handle it, were we as clear as we need to be and could be? That's the question. On our website or wherever we send information.
Well, the claim is not listed in the general application form.
That you have to do it separately.
Right. Well, it's one of the bases for an application.
So you can do it as one application now since the statute of limitations has been lifted. But for example, in this case, having these particular tenants not having been identified as protected occupants for whatever reason that the landlord determined, they do have the option of filing for protected occupant status. There's no statute of limitations for that.
I guess I'm not questioning that. I guess what I'm asking is if in fact we've changed the way we look at it, were we clear as we could be other than the specific application on our website, in our disclosure? I mean, have we been as clear as we could be?
Do that.
Okay.
You know, but I do believe that, I mean, for somebody who does not have an attorney, perhaps they didn't know. But every attorney that practices before us is aware of it.
Martha, did you say that in the law court general application forms that currently exist,
Yes.
there is now, would you repeat that again?
There is under the basis, there is somewhere where you can check off that says protected occupant.
Somewhere you could check it off.
Right. Well, you know, it
On the
says
application.
harassment, you know, I'm trying to think of this. Harassment, demolition of services, and one of them is protected occupant status.
And if I don't check that and I just check coverage, in this case, what happened as I read it, number 7, is that they filed an application and then they only registered. So there was never a proceeding where the applicants could have said, oh, and by the way. So what you're saying is if you don't check both those boxes, we're only going to look to whether or not the unit is covered, even if you demonstrate the residential use of the window, of the unit during the window period by presenting proofs of your presence. If you don't affirmatively ask for being a protected occupant, we're not going to find you to be a protected occupant.
As it currently stands right now, they're not on the same form. You have a form for coverage, and you have a form for the protected occupant status.
So if Chuck Delaney at 76 Pearl Street, 3rd floor, wants to be the protected occupant of 76 Pearl Street, 3rd floor, I would have to file 2 applications.
Well, you would have to, if you file a coverage application, you say in the coverage application that you want coverage for your unit, and you want coverage as a protected occupant, I think we have had cases where we have let that claim go forward, and we will rule on that claim. But if today, or during the time period where you couldn't file coverage, you could go to the general application form and check off protected occupant status. At the time, you didn't know that the statute of limitations would be lifted, so we added it to the general application form, where you can file that application form for protected occupant status.
And that was, as I recall, shortly before or shortly after March 11th, 2014, when the statute of limitations was imposed. The board staff stated that it was their interpretation, correct? That someone could still apply for protected occupant status if a unit had already been, was either covered, had been found to be a covered unit, or there was an application pending that came in before the deadline.
I couldn't say when that position was stated, but I know it was at some point, but I don't know when.
I frankly don't understand how a unit could be covered without an occupant. Doesn't make sense.
It's not that it didn't have an occupant. It didn't, and what we're saying here is that there's no proofs as to protected occupant status. Somebody can be an occupant of a unit and not be the protected occupant. Somebody can be the window period tenant and not be the protected occupant. Somebody can be the protected occupant who came in 4 years after the window period.
Well, okay. In that case, if the unit is illegally occupied, whatever the hell that means, right? But it is occupied, then it could be a covered unit. Then it's a covered unit.
Yes.
I don't understand it. So it's illegally occupied, but it's a covered unit. But the people in there, because they didn't file, didn't say that they were there as of January 2011 or whatever, then they are not protected. It just, you know, it just doesn't make sense. It seems to me that to make it a little simpler, there should be one rule about it. Both protected and for the tenant as well. Otherwise, it just doesn't make any sense. So there's spaces out there that are covered, but who knows whether anybody's living in them or not living in them. So let's say the landlord is there. I mean, there was one building here with 70 units or something like that we sort of had. So let's say 20 units there are covered and nobody's living there. So then what do we do? We say, well, it's too late. The landlord covered, but you can't move in there. I mean, there's a little disconnect here. I don't think I have a solution to it, but there is a disconnect. Sorry.
I would like to ask that we vote on case number 7 separately, since I plan to vote no.
Okay. Is that all right with everybody? Anyone else? Comments, questions on any any of the other cases? All right. Is there a motion to accept cases 1 through 6 of the summary cases? Mr. Schachter, thank you. Second. Mr. Barowitz, thank you. Can you poll the members, please?
Mr. Carver,
Yes.
Mr. Barrett,
Yes.
Mr. Gregory,
Yes.
Ms. Chairperson Fisher,
Yes.
Mr. Delaney,
Yes.
Ms. Bolden Rivera. Yes. Mr. Schachter.
Yes.
7 in favor, 1 absent.
Thank you. Now is there a motion to vote on case number 7? Mr. Carden, thank you. Do I have a second? Mr. Gregory, thank you. Can you poll the members, please?
Mr. Carver,
Yes.
Mr. Barrett,
Abstain.
Mr. Gregory,
Yes.
Chairperson Fisher,
Yes.
Mr. Delaney,
No.
Ms. Bolden Rivera.
Yes.
5 in favor, 1 no, 1 against, 1 absent, 1 abstain.
Thank you. Motion passes.
Wait a minute, I got a no and an against. Don't count me twice. Just no.
One no.
No and? No, we had 5 yes, 1 no, 1 against, and 1 abstain.
This twice. We
Your
have,
vote counts for so much.
Well, you know, it is what it is.
we now come to the master calendar case calendar. We have 2 coverage cases. The first coverage case is Fiona Campbell Stone et al., 1315 Thames Street, Brooklyn, PR 0889. Ms. Cruz, can you present this case, please?
On April 21st of 2011, 9 occupants of Unit 1W filed a joint application seeking Article 7C coverage and protected occupant status. On February 1st of 2013, at a hearing, the prior owner agreed that 7 of the applicants were protected occupants of Unit 1W. Prior to the filing of the coverage application, the Department of Buildings issued a partial vacate order for the first floor, including 1W. On January 16th of 2014, the law court issued order number 4225, which in part rejected the portion of the stipulation that granted seven unrelated people protected occupant status. The agreement violated the occupancy permitted in section 4 of the multiple dwelling law. The board remanded the protected occupant claims to. Based on the analysis under 281.2.1, Judge Spooner recommended that the board grant Mr. Teichberg's claim for protected occupant status and deny the protected occupant status claims for the other occupants. The staff recommends that the board accept Judge Spooner's recommendation that Mr. Teichberg recommendation to accept Mr. Teichberg as a protected occupant, but for different reasons. The staff also recommends that the board accept Judge Spooner's recommendation regarding Stone, Mr. Aleska, Mr. Foster, and Mr. Westbrook, but reject his recommendation for Mr. Beckford and Mr. Howe. The law court rules governing protected occupancy determinations are found in section 209B. Instead of using 209B for the analysis, Judge Spooner uses MDL 286.2.1 to require proof of a rental agreement or a lease as a condition for protected occupant status. The staff recommends that the board reject Judge Spooner's analysis. The language in the statute does not require an occupant to have a rental agreement or a lease for protected occupant status. It merely states that the rent paid by the protected occupant should be the rent specified on the lease or rental agreement if one exists. Judge Spooner also relies on several law court orders for the proposition that an occupant must have a lease or a rental agreement to be a protected occupant. However, as explained in the proposed order before you today, the holdings in these cases do not support the proposition that a lease or rental agreement is necessary for finding a protected occupant status pursuant to 209B1 and 2. Sections 293 and 4 requires, among other things, that the law court consider whether there's a lease or rental agreement, but the lease or rental agreement is not required for the law court to grant protected occupant status pursuant to B1 and 2. In this case, the record shows that Joshua Slusher entered into a lease with the prior owner for the term beginning on September 1st, 2009 and expiring August 31st of 2010. However, because Mr. Slusher is not seeking protected occupant status in this case, the analysis of protected occupant claims should be made pursuant to 209B1 and 2, or where occupancy began after the effective date of the law under B3. The staff recommends that the board grant Mr. Teichberg's claim for protected occupant status pursuant to B1 and 2, which apply when an occupant is in possession prior to the relevant law and remains in possession of the unit. Mr. Teichberg took possession of the unit in 2009, well before the effective date of MDL 815. Although Mr. Teichberg is not in actual possession of the unit, the staff recommends that the board accept Judge Spooner's recommendation to grant protected occupant status. Mr. Teichberg occupied the unit at the time of the vacate order. The vacate order legally prohibits Mr. Teichberg from actually occupying the unit. He's unable to reside in the unit by no fault of his own. Under these circumstances, he should be deemed to be in constructive possession of the unit until the vacate order is lifted. The staff recommends that the board reject Judge Spooner's recommendation to deny Jason Beckford's claim for protected occupant status. The evidence in the record shows that Mr. Beckford residentially occupied the unit since 2009 and that he resided in the unit at the time of the vacate order. The staff recommends that the board grant Mr. protected occupant status. Although Mr. did not appear for the remand hearing, the record shows that he occupied the unit in 2009. He had a sublease beginning in April 1st of 2009 through December 31st of 2009. The coverage application was filed in 2011 and he signed it. Therefore, it is more likely than not that Mr. Hout was in the unit prior to June 21, 2010, although through at least April 2011, which includes the date of the vacate order. The staff recommends that the board deny the protected occupant claims of the remaining 4 applicants, as with Mr. Tout, Mr. Beckford, and Mr. Hout. These 4 tenants were required to show when their residential occupancy began and whether they were in possession of the unit on the date of the vacate order. Regarding Ms. Stone, Judge Spooner found that her testimony was not credible. Ms. Stone offered no documentary evidence to show that she occupied the unit prior to June 2010. Without the proof she occupied the unit prior to June 21, 2010, Ms. Stone is not entitled to protected occupant status pursuant to 209B1 and 2. Ms. Stone's claim also fails under 209B3. Ms. Stone is not a primacy, nor does the record establish that the owner or its predecessor ever consented to her occupancy. There's nothing in this record to show Ms. Stone was an assignee of a primacy with the owner's consent. Regarding the claims of Peter Alexa, Stephen Westbrook, and William Foster, the staff recommends that they be denied. They failed to appear for the remand hearing, and there is no documentary evidence in the record regarding their occupancy. Judge Spooner found the testimonies of Mr. Teichberg, and Mr. Beckford, and Ms. Stone about these occupancies were vague. As such, the testimonies are insufficient to support a finding of protected occupancy for them.
Thank you. Comments or questions about this case? Mr. Delaney.
I'd like to repeat everything I said before, but how big is this unit physically?
I'm sorry?
Do we have any idea how big this unit is?
Yes, we do.
How big is it?
It's 2 3-story buildings. I Googled it. 2 3-story buildings that are joined together, so it's one unit. So it looks like the ground floor is enormous.
Can I just,
There are murals in front of the building.
let me respond to the actual size of this unit. I can't give you the square footage. I can tell you that we had plans and had narrative statement conferences about this unit. We've had pictures of the unit from before the vacate. So the unit has windows. It's a long unit, has windows on each opposite side. In the middle, they had curtained off, I wouldn't really call them rooms, but spaces. And so they had 1, 2, 3, 4 spaces, and then across 1, 2, 3, 4. So that is about how the setup of the unit was.
Go ahead.
This is case 8, right?
Yes.
Okay, so we have in the, I think we have that, the information in the materials provided. It's 5,000 square feet. Is the description that seems to be the consensus.
I can live with that.
I have no idea what the square footage
That 5,000 square feet, that there's one large common space used for art presentations and 7 to 8 smaller rooms.
Well, there were no actual rooms.
So,
They're not rooms, they're allocated.
Space.
Is it just curtained off?
Yes.
Yeah, okay, so curtained space. Okay, I'm sorry.
now, at one point, the prior owner stipulated that 7 of the applicants were protected occupants. And our objection to that is predicated on the maximum allowable size of number of occupants of a unit. Is that correct? Okay. If the owner had only stipulated to 5 occupants, would we have accepted that? You could have stipulated to Ms. Stone, for example. We would have accepted that. But he stipulated to 7 people, and we didn't accept it. Did the board ever entertain that perhaps one of the requirements for legalizing this unit would have been to divide it into 2 separate units if it had 7 occupants?
They applied for one space. They applied as one space.
Sure, and we frequently cover spaces that have to go through transformations and changes to be legalized, don't we?
It would have to be the owner who would be willing to do that.
Well, the owner was willing to rent to these people.
Well, you know,
The law says to the owner, hey, you got a covered unit, you got a covered building, you have to legalize it.
Mr. Delaney, if the owner wishes to allocate to one of these tenants a protected occupant status, he can do that, provided he does it within the limits of the multiple dwelling law. We are not called upon to make that determination. We're called upon to make the determination based on the rule. As you well know, because you bring it up, there's a sort of dichotomy here. A tenant has to prove that they are a protected occupant in order to be a protected occupant. But the owner has the ability to say, you don't have to prove it, I concede it, I stipulate it, I register you as a protected occupant. And the owner can still register the appropriate number of people in the unit if the owner so chooses.
The appropriate number.
In other words, with regard to the multiple dwelling law and the allotted number of people that you're permitted to have in the
I
unit.
see, I see. Okay. With regard to Nico Haupt, we find that Mr. Haupt is a protected occupant. I've never seen us use a descriptor as more likely than not.
Well, he didn't testify at the remand hearing, but based on the information in the record, it was safe to say that he was there. He was there prior to the effective date of the law, and he filed the application after the vacate order was issued. He was part of the application that the tenant jointly filed.
And with regard to Ms. Stone, I guess we find she's less likely or not to be a protected occupant. And our second paragraph on Ms. Stone states she's ineligible for protected occupant status pursuant to 209B3. Ms. Stone is not a prime lessee, nor does the record establish the owner or its predecessor ever consented to her occupancy. However, the predecessor did stipulate to her being a protected occupant.
The owner can stipulate, the law court, when it makes determinations determinations must be based on the rules.
Well, here we're citing the record rather than the rules.
Well, the rule requires that you either, the problem with Ms. Stone is that the testimony that she provided was not found to be credible. So she testified that she was there, I think, in May of 2010. Judge Spooner found that to be not credible. And what she was there, she testified, he found her not to be credible, and she didn't submit any information to support her claim that she was there prior to the effective date of the law. So if you're there prior to the effective date of the law, you don't need the owner's consent pursuant to 209(2). But if you can't prove that you were there prior to the effective date of the law, then it's B3 that's triggered. Then we have to go to B3, and B3 requires that you're either a prime lessee with a lease, or that you're an assignee, or that you established privity with the owner.
Does it surprise you that I'm going to vote no on this case?
No.
There are a couple of, I found laugh out loud moments in Mr. Spooner's report and recommendation, but I'll spare a dramatic reading of those. He does bring up a notion of the concept of accidental presence of a roommate. Do you have any idea what Judge Spooner is talking about?
No.
No. Okay. All right. I don't think it's fair to ask you folks to address some of Judge Spooner's logic, because you rejected a considerable amount of it, so
We appreciate that.
I will urge my colleagues to join me in voting no, and save the rest for writing an opinion.
Anybody else have any questions or comments?
Let's call the question.
Is there a motion to accept this case? Mrs. Gregory, thank you. Is there a second? Mr. Thacker, thank you. Board members, please.
Mr. Carver,
Yes.
Mr. Barrett,
Yes.
Mr. Gregory,
Yes.
Chairperson Fisher,
Yes.
Mr. Delaney,
No.
Ms. Bode Rivera,
Yes.
Mr. Shannon.
Yes.
6 in favor, 1 against, 1 absent.
Thank you. The second coverage case is 657-665A Fifth Avenue Tenants, 657-665A Fifth Avenue Brooklyn, TR 1125, 1126, and 1130. Ms. Cruz, please present this case.
On October 2nd of 2013, the occupants of the second floor at 657 Fifth Avenue filed an application seeking coverage for their unit pursuant to MDL 285. On October 4th of 2013, the occupants of the third floor unit in 657 Fifth Avenue filed an application seeking coverage for their unit pursuant to MDL 2815. On October 31st of 2013, another occupant of the second floor at 657 Fifth Avenue filed an application seeking coverage. In a stipulation between the owner and the tenants, the parties agreed that the buildings located at 657, 661, 665, and 665A Fifth Avenue are horizontal mobile homes. The buildings were occupied for residential purposes by 3 or more families living independently from one another for a period of 12 months, 12 consecutive months during the relevant rental period. That the second and third floor units meet all the statutory requirements for coverage pursuant to MDL 285. That 657 Fifth Avenue lacks a certificate of occupancy pursuant to MDL 301. That the tenants are protected occupants of their respective units if the units qualify for coverage. And lastly, that the first floor of 665A Fifth Avenue was occupied for residential purposes during the rental period. Parties also agreed that the only legal issue remaining is whether the first floor at 665A Fifth Avenue is subject to rent control. Because the owner failed to demonstrate that the first floor at 665A Fifth Avenue is subject to rent control, the staff recommends that the board find that the building is an IND with 2 units on the one on the second and third floors of 657 Fifth Avenue, and the tenants are protected occupants of their respective units.
Questions or comments about this case? Mr. Delaney?
If the unit that the landlord's attorney raised, about which the landlord's attorney raised the question as to whether or not it's a rent-controlled unit, if it were a rent-controlled unit, is that relevant to establishing 3 separate residential units in a building without a residential certificate of occupancy?
No, you put that in your position. Well, fortunately, for this case, we don't have to go there. But we do anticipate we will be going there soon. The question would be, that Martha and I are discussing quite often, is if one of the 3 units was residentially occupied during the window period, but does not meet all of the eligibility requirements for coverage under the 281.5 statute, can that unit then be counted for the requirement of 3 individual families living independently or whatever it is? My position so far has been leaning towards no. You can't use it. Martha's opinion is different. So we'll see what happens. But that is a really good question, and we have been really thinking about that, about whether you can. We would be able to under the previous law, to just say there were 3 units with people living independently, didn't have a certificate of occupancy. What was the other one? Had a window, no, we didn't do windows. What
3 units independent, former commercial use.
Former commercial use, no certificate of occupancy. And that was enough. But I would venture to say that if one of those units had a certificate of occupancy, what would we have done? Did we ever have one of those cases?
Yes, you have.
So what did you do?
Well, it was an accessory use where the butcher lived on the top floor in the building, which had a butcher shop on the ground floor and 3 floors of meat. An accessory use unit that was residentially occupied counted toward the count of 3 for an IMD.
The other question is whether that's a 301C or not a 301C. If it's not a 301C, then it should count.
But if it is
Well,
301, then it counts.
Forgive me, this is a question that we will be revisiting in the context of a different case and a different fact pattern than this case. Am I correct in that?
I'm not sure that it comes up.
No.
We bandied it about with regard to what if, somewhat like you do.
What if the 3rd rent-controlled unit was 300 square feet
Yeah.
above a dynamite factory?
Right.
Would it count?
Right.
Okay, I understand that. But in this case, none of those concerns exist.
That's right. So
So,
we don't have to.
well, if we don't have to really, then why do we have that the owner failed to demonstrate as the first sentence of the second to last paragraph?
Well, because the owner failed to demonstrate, we don't have to reach that question. And
Avoid the controversy
That's right,
entirely.
exactly.
He's already agreed that the 2 units that are applying for coverage already meet every of the eligibility criteria for coverage.
And so that one unit, which was not found to be rent controlled, but was residentially occupied during the window period, can count. Therefore, we do not have to worry.
I'm sorry. Let me read the 2 sentences. The owner failed to demonstrate that the first floor unit at 665A Fifth Avenue is subject to rent control, period. Accordingly, it may be counted as the 3rd unit independently occupied during the window period. However, I would argue that even if the owner had demonstrated.
But we don't have to go there.
That is not pertinent for this case. Which is not to say it's not an important issue to be discussed when it does become pertinent. But for this, we've dodged the bullet for this situation?
Yeah, I think you've dodged the bullet but muddied the waters. Why do we need to have either of those two sentences in there? Because the implication is, accordingly it may be counted, the implication is, well, had he demonstrated, it wouldn't be counted.
I think it's, had you demonstrated, we would have done the analysis for it.
That was the whole point of claiming that it was rent controlled by the owner, was to say that they did not have 3 eligible apartments.
You just want to make sure that nobody reading it gets the wrong interpretation that if the fact pattern had been slightly different, then.
That's exactly correct. What we're going through now is a period where the board is making rules by decisions rather than by promulgation and public hearing. This sentence clearly would seem to suggest to me, if I were a lawyer who was not drenched in loft law, case law, that we seem to be saying, if it had been demonstrated that it was subject to rent control, it would not be counted. That's why I question whether this, if the new answer is, we're going to resolve controversies by making lawyers rich because they have any idea how to properly present your case to make sure your clients get covered and that the unit is covered and that your clients are protected occupants. You got to read all the case law and read our cases. I think this sentence is misleading. I would recommend that it be deleted.
Since we do not reach that question, shall we merely delete it?
That's the whole.
Or do you want to?
Because that was the claim. The claim, I would think that if it's the owner's claim that the building is not eligible for coverage because it has one unit that would not be, that would make it ineligible because there are only 2 that would meet the eligibility criteria, that was his case, wasn't it?
Yes.
So then you have to say, no, they are all 3, it's not rent controlled, so you lose, owner, and this is the reason why. So what you're saying is, and we shouldn't say, and by the way, I mean, I'm really not understanding what your problem is.
All 3, that contrary to the owner's assertion, all 3 apartments are eligible and therefore,
And so, with any lawyer who reads that thinks what?
that the owner made an assertion that one of the apartments was ineligible and we disagreed.
And because it was ineligible, it was eligible because it was rent stabilized, what is the next thing that you as an attorney would understand? That had it been rent controlled, we might have come out differently.
That would seem to be what the sentence implies.
And that is exactly what it is, isn't it? Isn't that what we're saying?
I don't think we're answering the question.
We're not. We're saying, had it been otherwise, had you proven owner otherwise, then we would have to make a different determination. Then we would have to go and make the determination of whether Ms. Cruz's interpretation or my interpretation is the way to go.
Let's come at this from one more angle. If I thought I understood you to be saying earlier that the definition of eligibility for qualification is an IMD prior to the 2010 section that added 281.5 merely required 3 units being used for residential, former commercial occupancy, lack of a residential CO. In that case, this was demonstrated, they cite Blackwell v. Milne, which is the key case in this. If there were a rent-controlled unit or an accessory use unit, it would still count toward the threshold number of 3 units being used residentially.
was a case that came before the board in which the board held that the prior rent control status of the unit did not bar it from seeking status now.
Because the rent no longer
They're
was
subject to rent. control.
14th Street, yeah.
Right.
Right, I remember. But that's not the case we're in here. That's a totally different, that wasn't, isn't the linchpin of the third unit coverage case. So again, at the risk of repeating myself, I read the sentence, accordingly it may be counted as the third unit independently occupied during the window period as saying, had it been demonstrated to be subject to rent control, it wouldn't be. And I don't think that's what you mean to say.
We have not had a case like this before. This has not come up before. But it was one rent control unit and two other units that
The
were
only case I remember that's similar where it turned out a third case was where the unit was on the C of O, a non-residential C of O as an accessory use. Which was frequent in the old days. You'd have a watchman or a caretaker or the owner living in an otherwise commercial building.
All right. I mean, for the sake of this unit, I think this is a kind of rare circumstance. So I think we ought to just approve this and let it go. And I don't know what lawyer is going to suddenly glom in on this thing and start making a fuss about any subsequent cases that are coming up. I mean, may be wrong, but, you know, most of these buildings that we're looking at have multiple units, far more than three. So,
Yes, that's the fact.
Any other questions or comments?
A motion to accept this case. Mr. Barrett, thank you. Mr. Gregory is the second. Thank you.
Mr. Garber,
Yes.
Mr. Barber,
yes.
Mr. Gregory,
Yes.
Chairperson Fisher,
Yes.
Mr. Delaney,
No.
Ms. Golden Rivera, Mr. Sheffield.
Yes.
6 in favor, 1 against, 1 absent.
Thank you. This will conclude our May 19th, 2016 Lockport public meetings. Our next public meeting will be here at Spector Hall, 22 Reed Street, first floor on June 23rd at 2 p.m. 4